Today's ruling in the case of Dr. Kizza and Lutale has prompted discomfort among the accused's lawyers, leading them to take the next step of filing a judicial complaint against the Nakawa Chief Magistrate over the handling of the treason case.
Our clients, not we as lawyers, our clients deemed it appropriate to drag the magistrate to the Judicial Service Commission for disciplinary action because of that gross incompetence and abuse of the judicial oath. And also, we were instructed to seek for a recusal, rather to seek a recusal, which we have appropriately done here.
Lawyer Lukwago asserts that judge lacks jurisdiction to examine Dr. Kizza's phone for evidence as the case has already been filed in the High Court for trial. He argues that such an action would constitute an overreach of the judicial authority.
What do they do with whatever evidence they are going to gather after committee? Because we have already made the committee proceedings. You have already forwarded the High Court to, you have already forwarded the file to High Court. It's already before High Court for trial. Now, whatever evidence they are going to gather subsequent to the committee, how is it, to what effect? Is for what purpose? So it's just even a matter of logic. You, even non-lawyers, you can even tell that actually what she's doing is irregular. So it's the reason we...
On the 20th of June, lawyers will be eagerly waiting for the Nakawa's judge's final ruling. Notably, the judge's authority to handle the case may be limited, potentially requiring the Judicial Service Commission to intervene and take further action.
Because we have made our case, or the case for our client has been made, and I think we have done our best under the circumstances. We have executed our duties. We have indicated to her that after committee, she has exhausted her mandate. She has no jurisdiction whatsoever. She has no residual powers to conduct any business concerning Dr. Kizza and Lutale matter. She has no business with Kizza. No business at all. This is what we are telling her. So to purport to come up with that application is abuse of the judicial oath. And now you are asking, yes, was she aware of the complaint we took to the Judicial Service Commission? That much, well, we don't know because we served the court. That was this morning, but we supplied her with another copy. So it's okay. Whether she has convened or not, at least now she knows that there is a matter against her before the Judicial Service Commission, where now the accused persons or the applicants, Dr. Kizza and Lutale, are taking her on.
Speaking to the non-lawyers, these have expressed disheartened towards the judge, revealing the lack of knowledge about the laws which they do believe have been defiled by the judges.
Judicial power is derived from the people of Uganda, and therefore that must be exercised without bias, without personal interest, without emotions. And therefore, as non-lawyers, when we see somebody who holds judicial power putting in emotions and personal interests, we don't even need to be lawyers to know that such a person should not be in such a position.
Twasubira nti babasindise mu High Court, yabasindika mu High Court. Ekyo bwe kye tumanyi muteri go basindika mu High Court nadda. Kakati ate bwe yamala basindika mu High Court tugenda okuwulira mbu abakomezaawo. Ekyo twakyewuunya. Olaba mutegeeza nti munnange twakulopa mu bakama abo olw'enkola y'embi ey'emirimu. Kiwalirowooza nti bakimulaze mune muteeka ali ekamanyo katambuzaako akempisa waliwo sikululuuzi naffe ze twasomanga.